Have you ever wondered what happens when two people from different worlds want to build a life together? Imagine a couple, deeply in love, but their personal religious laws create hurdles to their union. This is not just a story from a movie, it is a real-life situation for many. India, with its beautiful tapestry of diverse cultures and faiths, needed a special path for such couples. The Special Marriage Act of 1954 is that very path. It is a powerful law. It allows people to marry based on their love and consent, not their religious identity. This act provides a civil contract of marriage, a secular alternative that stands apart from religious ceremonies and personal laws. In this video, your simple guide, we will see who can marry under it, who cannot, and what the courts have said through case law. Do watch, share, and subscribe if you find it helpful. The Special Marriage Act, 1954, is a unique piece of Indian law. It governs civil marriages, unions that do not follow religious rites. Think of it as a neutral ground, a legal space created by the government for any two individuals to marry. This law applies to the whole of India, providing a uniform procedure regardless of faith, regardless of the couple's caste and creed. Its purpose is to give legal sanctity to a marriage without any religious ceremony. It is invaluable for couples from different religious backgrounds who do not wish either partner to convert. This act offers a complete code. It covers solemnization, registration conditions and consequences, like divorce and succession under secular law. To marry under the Special Marriage Act 1954, a couple must meet clear conditions. These rules ensure validity and genuine consent. The first condition is age. The male partner must have completed 21 years. The female partner must have completed 18 years. This prevents child marriages. Proof of age is mandatory. Second, mental capacity. Both must be of sound mind. If a mental disorder makes a person unfit for marriage and procreation, the act does not permit the marriage. Consent must be free and genuine, not by force, not by coercion, and not by fraud. Religion does not matter. A Hindu can marry a Muslim. A Christian can marry a Sikh. Two atheists can marry each other. The act applies to Indians and foreigners. If one partner is foreign, the marriage must take place in India. At least one party must have resided in the district for 30 days. While inclusive, the act lays down specific prohibitions. These protect the institution of marriage and the individuals. They rest on public health, social order, and basic human decency. Underage marriages, below 21 for men and 18 for women, are void from the start. No marriage if a party cannot give valid consent due to unsoundness of mind. If unfit at the time of marriage due to a mental disorder, the union can be declared void. This protects vulnerable individuals. It does not stigmatize illness. The act forbids marriage within prohibited degrees of relationship. Finally, bigamy is absolutely prohibited. A person already legally married cannot marry again unless the prior marriage has legally ended. The act is built on monogamy. One person can only be married to one other person at a time. At marriage, neither party can have a spouse living. This is a core condition of validity. Choosing this secular act means abiding by its rule against bigamy. A prior marriage must have ended by a final decree of divorce or by the death of the spouse. Marrying again while a prior marriage subsists makes the second marriage null and void. It is also a crime under sections 494 and 495 of the Indian Penal Code, punishable with imprisonment and fine. This protects the new spouse, the first spouse, and ensures legal clarity for families. Beyond age and monogamy, the act forbids marriage between close relatives. These are the degrees of prohibited relationship, listed in the first schedule. Lineal ascendancy, no marriage with ancestors or descendants. For example, one cannot marry a mother, grandmother, daughter, or granddaughter. The same applies to women and their lineal kin. Collateral consanguinity includes siblings and cousins, and extends to uncles, aunts, nephews, and nieces. You cannot marry your brother's daughter or your sister's son. A limited exception exists if a well-established, continuously observed custom permits it, and it is not against public policy. For most people, the prohibitions apply strictly. Before giving notice, couples should check the list carefully. Marrying under the Act is systematic. It begins with a notice of intended marriage. One partner submits this notice in writing to the marriage officer. The officer must be in the district where at least one partner has lived for 30 days immediately before the notice. The notice includes names, ages, and addresses. This is the official start. The officer enters the notice in the marriage notice book. A copy is posted on the office notice board. If a party lives elsewhere, a copy is sent to that district too. A 30-day public notice period ensures transparency. Objections may be filed in writing, but only on legal grounds under the Act. Examples include underage, a subsisting marriage, or prohibited relationship, not personal dislike. If an objection is filed, the officer must inquire within 30 days. If no valid objection, or it is dismissed, the marriage may be solemnized. The couple and 3 witnesses appear before the marriage officer. Each declares, "I, name, take thee, name, to be my lawful wife or husband." All sign. The officer seals. The marriage is complete, and the certificate is conclusive proof. The journey is not always smooth. Many face family or community opposition. Interfaith and intercaste unions often meet resistance. Recognizing this, courts across India, including the Supreme Court, safeguard individual rights. Landmark rulings affirm that the right to marry is part of the right to life and personal liberty under Article 21. Courts direct police protection against threats or illegal confinement. They restrain interference and remind officers to facilitate, not obstruct. Courts note that public notice invites lawful objections, not social vigilantism, and have reprimanded officials creating hurdles. These decisions ensure rights are real, uphold consent and autonomy, and strengthen the Act as a tool for freedom. Parents cannot use force, emotional blackmail, or false cases to break lawful marriages. The law supports 2 consenting adults. The Special Marriage Act, 1954, is a declaration of freedom. It offers any 2 adults a secure, legally recognized pathway based on mutual love and consent. Its pillars are clear: legal age, sound mind with free consent, no living spouse, and no prohibited relationships. The process is transparent and administrative, culminating in a conclusive certificate. Courts provide a robust shield, from police protection to clarifying procedures. The Act embodies secularism, liberty, and equality, honoring the right to choose a life partner. If documents are missing, a prior marriage exists, or objections arise, seek professional legal advice. Do watch this interesting video and share and subscribe. And if you like it, hit the like button for more content on law.